Court of Appeals, Division 1 is now in session.
Good morning. Thank you. Please be seated. Thank you for your courtesy. This is the time set for oral argument in a case entitled Anderson and Others versus City of Prescott. Our cause number CV130458. We have reviewed the facts and issues. We've conferenced the case. We're interested in your arguments. Each side has 20 minutes. If appellant wishes to save some time for rebuttal, feel free to do that. You'll have to watch the clock yourself, and we'll try to honor that if you want to do that. We're being recorded, so as each attorney comes to speak, if you would state your name and the party you represent, that would be helpful if somebody listens to this later. And also, I guess we're giving fair warning that we're videotaping these things now out of cameras that are around here in tourist places, and it will be posted in due course. So having said that, we're ready for counsel for appellant.
Thank you, Your Honor. My name is Mark Drutz, and I'm here with Jeff Gautreaux, and we're from the Prescott law firm of Musgrove, Drutz, and Cack, and we represent the plaintiffs. And we are seeking a reversal of the trial court's decision that the plaintiff's claims filed in the Yavapai County case were barred by the one-year statute of ARS 12821. This case pertains to a gate that was erected on Donner Trail in Prescott, Arizona. The most recent vote to remove that gate occurred in May 2012. And that vote went against the plaintiff. It was 5-2, but that vote reset the clock ticking for the statute of limitations.
I gather that you agree that the statute, what is it, 12821, applies, the one-year statute.
No, well, it applies, Your Honor.
It applies, but your argument is that it didn't accrue until that latest vote.
It didn't accrue to that latest vote, 12821. In addition, we have another argument that we think is persuasive, which is that it's a continuing violation of our client's constitutional rights to have that gate in place, and the cause of action didn't accrue until, frankly, the day before my client filed the lawsuit, because the gate remained there, and so a new cause of action accrued every day. 12821 generally applies, and I know, it says...
Is it your contention that every violation of a constitutional right is a continuing harm that accrues every day?
Well, I think if in fact you're seeking declaratory relief and injunction, I think you can make a good argument that you have a continuing violation of a constitutional right on a day-by-day basis.
Did you, excuse me for interrupting, and we will let you get your position out, I'm pretty sure. When you mentioned declaratory relief and injunctive relief, are you drawing a big red line between those kinds of things on the one hand and damages on the other?
We are. I think there's a significant difference between, say, a personal injury case where somebody makes a claim against a government entity and they have to do an administrative claim and they have to file suit within 1 year. We had no administrative claim requirement. Our claim sought declaratory relief and an injunction in that we're challenging the constitutionality of the city's decision to erect this gate. And we have 4 claims that are based on constitutional challenges. And significantly, the trial judge denied the city's motion to strike our constitutional claims. The only reason we're here today on appeal is because the trial judge believed that 12821 required that my client file a lawsuit within a year of when the gate was erected. And that gate was erected in 2007. So according to the lower court, our claim would have been barred in 2008, 2009, perhaps at the very latest. But what is significant is that in our case, the city of Prescott continued to discuss, continued to debate, and continue to vote on whether or not that gate should be taken down. They voted on it in 2008. They voted on it in 2011.
Is there something in the facts that would say unequivocally that after the 2008 vote that I understood was purported to make the gate permanent, that after that vote there would be more discussion and more debate and maybe their mind would be changed?
Well, I think there was some indication with the plaintiff that decisions are always subject to review, and what the city did, in fact, is they reconsidered their decision. They reconsidered it in 2011, and they reconsidered it in 2012, which to us shows that there really wasn't any finality in the city's decision that that gate was, in fact, permanent.
But the reconsideration was not provoked by some sua sponte internal review by the city. It was rather initiated by your clients, wasn't it?
My client requested that the city reconsider it, but the city is not obligated to do so. I mean, they're not automatically required to put the issue of the gate back on the agenda for consideration and a possible vote by the city council. They could have simply addressed it in a study session and determined that they didn't want to pursue it, or they could have simply said to my client he could bring it up and call to the public, but they didn't have any obligation to put it on the agenda and vote. And our view is when they made a decision to put it on the agenda and vote, that had consequences to the city. Let's assume that the reverse had been true and that there had been, in fact, a favorable vote for my client in 2012 and they were going to take the gate down. Wouldn't the proponents of having the gate in place have had an opportunity within a year to have challenged the decision to take the gate down? I suspect that they certainly would have. And I think that the reverse should be true, in that my clients coming out on the losing end of the most recent vote in 2012 should have an opportunity within 1 year, assuming we're applying 12-821, to challenge that vote not to take the gate down.
Well, your argument then basically posits that there's no effective statute of limitations. There's no finality ever to any government action because the government can re-raise it or a citizen can re-raise the issue.
I think there's finality certainly on tort claims and something similar to that. But when you're asking for a revote by the city council and the city council elects to rediscuss it and revote on that, then I think that the statute of limitations, the clock begins to retick again. And I think one of the cases that's interesting that was cited by the city is really supportive of our position. It's that Canyon Del Rio versus Flagstaff case. If you take a look, Your Honor, at footnote number 2, it's really an analogous situation wherein the developer submitted a new proposal to the city of Flagstaff, but it had the same defect as the prior proposals that had been submitted. And yet the Court of Appeals in the Canyon case said that that did not inappropriately reset the clock, that when the new plan was submitted to the city of Flagstaff, that reset the clock ticking again. And that because that opened up discussions in the whole planning process and negotiations. And I think that's analogous to our situation, wherein the city agrees to reconsider the placement of the gate on Donner Trail and in fact votes on it, which they're not obligated to do, and by doing that, that restarts the clock ticking.
But what if they don't vote on it? I mean, isn't your argument really the same? If a citizen comes to the council and says, I want you to reconsider this action that a prior council took, and the council declines to consider it, wouldn't that, under your argument, restart the clock as well?
I think that when you have a more significant government action, such as putting it on the agenda, discussing it, and actually going to a vote, that's a much stronger argument, certainly, than if a person just goes and talks to the city manager or talks to one of the council people.
Dangerous, though, to describe statutes of limitation in terms of degree. I mean, statutes of limitation are supposed to be clear, black and white bars, and so if you're going to claim that the clock is reset, don't we have to have a bright line rule so that people know when the clock is reset?
I think the clock is clearly reset when the council puts it on the agenda and votes again.
But no statute says that, and no statute says that it isn't reset either in your situation or when a party simply asks the council to reconsider.
Well, I don't think you've got any government action when a person just comes in front of the council and asks them to reconsider an earlier vote. I think that's contrasted where you have positive government action where they put it on the agenda, they discuss it, they debate it, and they actually vote on it.
Is this any different in your view, this making of this gate permanent, than let's say a municipal decision to put a four-way stop in an intersection instead of a traffic light? Would that be the same kind of thing?
Well, the difference in our case is that, and this sort of flows into the constitutional argument, is that the city spent over $1 million of taxpayer money to improve Donner Trail. And having done that, they then decided to erect this gate at the end of Donner Trail, basically creating a private enclave for the people who live within Donner Trail. And that has impact on all sorts of people who want to drive across through Donner Trail to get to the adjacent neighborhood. So I think, Judge, it's a little different than your analogy because in this case, they actually used the taxpayer money to improve the street, and then the street was blocked off, benefiting only a select few of people, versus a stop sign versus a stop light. Although I will tell you, we had a similar situation where I live on Copper Basin Road, and that was exactly it. They put up a stop sign, and there were a lot of objections to it, and they ultimately took the stop sign down, and I think you could well make an argument that if somebody was going to object to the stop sign being taken down, their cause of action would have accrued from a year when the stop sign was actually taken down. And that is our similar argument, that when the government elects to vote as to whether or not they're going to put the gate up for the first time or the third time, whether or not they're going to take the gate down, then I think the statute of limitations clock begins to restart. I mean, keep in mind, the purpose of the statute of limitations is simply to prevent stale claims, and our claim by no means was stale. My client was exercising the political process.
But you contend that this is a continuing violation, right?
I do.
Okay. There are those who would contend that the government's use of tax funds to support stadiums, for example, is unconstitutional. Without getting to the merits of that claim, would that be a continuing wrong? Could any citizen, as a taxpayer, bring a claim asking to take down Bank One Ballpark or whatever it's called now?
Well, I suppose it would depend upon, what's the nature of the constitutional claim, when the cause of action would have accrued. The cases that...
Exactly what I'm asking is when it accrues, and you're claiming that there's a continuing wrong. So I'm asking you if any time a taxpayer wants to challenge a historical decision of a government that requires expenditure of taxpayer revenues, that claim is forever ripe.
Well, I think the taxpayer is going to have to show that it infringes on the taxpayer's constitutional rights. And you're making a good distinction, because I'm sitting here thinking how you would distinguish your analogy from the Tanco case, which we filed a supplemental citation of authority on, out of the Tennessee anti-recognition of gay marriage law, and how that that impacted those three same-sex couples. And the other case that we rely heavily on, which is the 10th Circuit case, that's the criminal case, it really has facts that are virtually identical on point, which are dealing with a resolution which was passed by a governmental body to bar the use of a road on an ongoing basis, and that was determined to violate the plaintiffs who wanted to use that road's constitutional rights, and that a new cause of action accrued every day. So I suppose, in answer to your question, Judge Swan, you'd have to, I guess, determine, whether or not the taxpayer who wants to challenge the Bank One ballpark can make a valid argument that his constitutional rights were infringed. But I do think, under, the general proposition is that if you can show that there is a continuing violation of your constitutional rights by government action, I think you would have the right to challenge that, at least for a cause of action that accrues that day. Now, maybe there's going to be a distinction in your analogy that the cause of action isn't accruing every day that the stadium is in existence, that perhaps, when the stadium is constructed or before the construction of the stadium occurs, certainly someone could have challenged whether or not you could use taxpayers' funds to build the Bank One ballpark.
Are you actually arguing, in the context of arguing a continuing harm here, are you actually arguing that there simply is no statute of limitations on constitutional claims? Constitutional violation?
I think if you can show that there's a continuing violation of your constitutional rights, that the statute of limitations accrues each day that law is in effect. And,
Why is it important that the rights are constitutional? What if it was just your property rights?
I don't think it raises to the level, I don't think property rights raises to the level of constitutional rights.
In a grand scheme, of course, I agree with you that constitutional rights are sacred, but for purposes of the statute of limitations, why does it matter if they're constitutional, property, contract, you name it?
Well, because the constitutional rights are going to, in fact, continue every day. Although with the property rights, we do have a case in Arizona, I believe it's the Garcia case, that talks about continuing trespass. And, what the Supreme Court has said in that case is where you have a continuing trespass, for the purposes of looking at the statute of limitations, you look at the last date of the trespass to run. So I guess, you could certainly make an argument that even with property rights, if somebody is interfering with your property rights through a trespass, that your claim accrues on the date of the last trespass.
What if it's the city council? What if I don't like the electrical code and I contend that it interferes with the value of my property? It restricts what I can do on my property. Is that a continuing harm that has effectively no statute of limitations?
No, I think that's a monetary claim, and I think there's a big distinction between seeking monetary compensation, which my client is not, because there are a number of cases that talk about statute of limitations, 12-821, specifically dealing with monetary compensation. But the law is much, much less clear when you're seeking injunctive relief or declaratory judgment as to the imposition of 12-821. Yes, Your Honor.
So what if Judge Swan simply wants the court to declare that the electrical code is not applicable to his property?
Or any property. I don't like electrical regulation. I think it violates the right of property owners to maximize the value of their property. So I ask the court to invalidate the adoption of the electrical code.
Well, I don't think that would arise to a constitutional issue.
It may not, but that's what I'm getting at. Does it matter that it's constitutional?
I think the case law across the country would certainly indicate that it matters whether it's a constitutional challenge, and I would concede that.
What case, though, draws that distinction between constitutional and property rights?
Well, I think the case that one of the cases that the city city talks about is the Mayor Unified School District case, and that case is talking about monetary compensation for a right-of-way. I think that might be more analogous to your example versus the cases we've cited, which are the Kunal case, which is cited with approval, and the Tanco case. And in part, I thought the Garcia case was relevant, although that's not a constitutional case. That's rather just a continuing violation case. But when you have constitutional issues in play that affect and or infringe on people's individual rights every day, then the statute of limitations restarts each day for that violation. And again, I think that's consistent with footnote 2 in the Canyon versus Flagstaff case that just simply talks about a developer resubmitting new plans that have the same defect. And the court acknowledged that, well, that restarts the discussion and that the statute of limitations should restart. If you have any further questions, I'll address them. Otherwise, I'm going to reserve my 45 seconds.
Let's reserve it.
Thank you,
very
Your
much.
Honor.
Good morning, Your Honor. John Palladini from the City of Prescott, City Attorney. Hopefully my case isn't as precarious as the water I spilled on my table. I think this case relies on a few basic premises, and first and foremost is ARS 12821, the statute of limitations, and the flood control district versus Gaines, which we cite, and in that case, this court talked about all means all. There is no clearer word than all actions against any public entity must be brought within a year. All means all.
But declaratory actions, for example, are not subject to the notice of claim statute, right?
That's correct, Your Honor, but the wording of the notice of claim statute talks about all claims, and the distinction, I think, in the statute of limitations talks about all actions. So it's a much broader net.
But surely you'd agree that there are some laws that can be challenged through declaratory judgment without regard to the statute of limitations.
I think, Your Honor, there is a distinction between the cases that the plaintiff cites that talk about that constitutional cases or constitutional claims can be brought without regard to statute of limitations, but those cases are distinct from this one. In those cases that they cite, including the recent ones that were filed, they talk about government ordinances, government statutes, government laws, and I think that the distinction there is that you have these ongoing enforcements of these laws. In other words, the case they cite, I think it's Coonley, or I'm not sure how to pronounce it. It's not on point. That case talks about a government resolution or a government sort of code where the truckers are prohibited from using this county roadway, but they're subject to being fined or subject to being cited, so it requires sort of additional government action. In other words, they'd have to be pulled over and cited by presumably a police officer or highway patrol. Same with the Tennessee case about the gay marriage. In those cases, you'd have to have an ongoing government act, which is the denial by the clerk or whoever issues marriage licenses for a same-sex couple. So in this case, and if you look, and I think there's a clear distinction, and in fact it arises out of the complaint itself. The complaint talks about the four Arizona constitutional claims, and they don't arise out of government votes or city council votes. What they talk about in their complaint is that in the gift clause, for instance, it's the paving of the roadway. Well, the paving of the roadway is a distinct act, and the council can't undo. I guess they could, vote to rip up the roadway or something, but in reality, that's a distinct physical act. It's a one-time occurrence. So the paving of the roadway is what gives rise to the gift clause violation, according to the plaintiff's complaint. Same with the other three allegations. It's the presence of the gate is what they say gives rise to the Privileges and Immunities Clause, the special law violation, and the tax provision violation. So, go ahead.
I was just going to say, so you don't agree that the mere presence of the gate is sufficient enforcement to allow the claim to be brought past 1 year?
I think the presence of the gate is a distinct physical act that should trigger or does trigger the statute of limitations. It's a physical act. It's there. It's open. It's notorious. It's obvious.
But then you have somebody who applies to the council to remove the gate, and the council says, no, we're not going to remove the gate. Why doesn't that restart the clock?
Well, I think, Your Honor, I think you hit on it earlier, that it's this huge slippery slope that if the council were to sort of reconsider it, whether it's at the request of a citizen or simply decline to reconsider it. Remember, and the city council is obligated to follow open meeting law. It can't sort of in a room on its own without violating open meeting law say, yeah, we don't want to discuss this matter. It really has to bring, if it's put on a council agenda, or if it's brought to the council, or even if it's brought in some sort of public forum or open forum kind of, you get your 2 minutes to talk about something that's not on the agenda. And the person coming up in front of the council says, please put this on an agenda and please vote on it. And it's never brought. The slippery slope is that this statute of limitations just never runs. And that's the problem with that argument.
Well, I recognize that that's the problem on one side, but isn't there a problem on your side too? I mean, don't you wind up with the position where the statute of limitations can be used to perpetuate constitutional wrongs, and you have basically a mere statutory procedural rule interfering with substantive constitutional rights?
Well, I think that the legislature set the rule as to 1 year and said all actions, and if the legislature wanted to make some sort of exception to that, it could have, but it really didn't when it wrote that all actions must be brought. But at the same time, I think there is a distinction. I think there are, and again, the plaintiff cites cases that talk about this. There are instances where the statute of limitations might not apply to an ongoing constitutional violation. But again, all of the cases that are cited have to do with laws, ordinances, statutes, things that are continue to be enforced, presumably by a government employee.
But the gate continues to be there. Let me answer the question that I was asking your colleague earlier as to the difference between constitutional rights and property rights. The legislature can alter your property rights. They can alter your contract rights. But the legislature can't alter your constitutional rights. By elevating a statute of limitations to the point of making constitutional rights unenforceable, would the legislature have exceeded its authority if we interpret the statute that way?
Well, again, I think that there are, I would agree that there are exceptions to the rule or to the statute of limitations, but those exceptions are limited to, and I'll go back to it, it's the notion that when there's a law or statute or ordinance on the books, it's unconstitutional, that it requires some additional government action to actually enforce it. The declining of a same-sex marriage license, the enforcement of some sort of prohibition of driving on a roadway. But when the government builds something, physically puts it in place, then the plaintiff in a case certainly knows it's there. Certainly, the time starts ticking. And moreover, when even if you want to look at the council decisions, when the council voted in August 08, which was about 2 years, give or take 2 years after the gate was actually installed and after the roadway was paved, it voted to make it permanent. There was never a discussion, certainly nothing alleged in the complaint that says that the plaintiff was somehow promised or it was ever alluded to that, hey, we may talk about this down the road someplace, no pun intended, we may talk about this in the future. In other words, how does the plaintiff even know to rely on the possibility that the government may take further action as it has the right to do, or may reconsider it, or may decline to reconsider it? That's the problem with the argument.
I agree that's a slippery slope, which is what makes this a difficult case. But take a new plaintiff. What if you have a plaintiff who didn't even live in Arizona at the time that the gate was made permanent, and comes to the area and realizes that the gate poses, let's say, a traffic hazard, and asks the council to remove it? The council says no. Does that person not have a right of action?
I really don't think that that person would have a right of action because again, that gate, it's not as if there was some secret or some unknown fact that when a plaintiff, say, were to move to the area or move to the and I think also it sort of that premise requires that this gate, in this particular case, this gate or the paving of this road, somehow has to have some direct impact. I don't think there is sort of this generic or general argument about this gate violating someone's constitutional right for a couple of reasons. One is that the black letter law talks about actions of the government are presumed to be valid or constitutionally valid. So there is that sort of concept that when the government makes a decision, there's a presumption of validity to that decision. So I think the plaintiff, a brand new plaintiff, would have to sort of come in and make a particularized argument. But I think that the plaintiff, a brand new plaintiff, would know that it's already there, and know that the roadway's there, and I think it would pose problems because the problem with that is there is a staleness then. I mean, how many years does the city have to wait? 20 years, 30 years, 40 years? Someone moves to the area and says, I don't like this gate. And I'm going to sue, I'm going to raise a constitutional issue 40 years after the fact when it may not even have any records showing the discussion about it.
Well, part of the problem may be casting a gate as a constitutional issue. I'm not sure that, it makes it difficult to discuss the statute of limitations, but you can imagine plain constitutional violations, right? I mean, a racially discriminatory residence requirement or some just abhorrent constitutional provision that may have been in place for quite a long time. Are you suggesting that a statute of limitations would apply to somebody who happened to be at the council meeting where that was passed?
Your Honor, I go back to there's a distinction. There's a distinction between the physical act, and by the way, we agree that the constitutional issues that were raised are that the fact that the trial court denied our motion to dismiss on the substantive issues merely is a function of a 12b6 motion. I don't think it leads any credence to their claims. However,
about merits here.
Right, but we're talking about I think there is a distinction between an ongoing enforcement that takes continued government action. In other words, if there's this racially motivated ordinance that prohibits African Americans and white people from living together, and the city, the town, people in town just sort of accepted it for whatever reason. And at some point, a mixed race couple moves to town. It would take some kind of enforcement to at least trigger that. I suppose somebody could make a facial challenge to it.
I would think a declaratory judgment action against that law would probably be ripe even without enforcement.
But I think if and we all know there's ancient sort of laws or old laws on the books that are never enforced, but they're still on the books. I think that those are the kinds of things, though, that do, at least in concept, require that in order to violate an individual's constitutional rights, that somehow the government would have to have at least some inclination of enforcing it. Because if it was simply a law in the books that was never enforced, was acknowledged never to be enforced, and but was simply left on the books for some reason, I don't know how really if that individual would truly have a claim. Certainly there's like you said, there's a facial invalidity type claim, but would the statute of limitations apply unless it was ever attempted or there was a possibility of an attempt to enforce? So I think it takes.
Let's say the person is chilled in some intended conduct and has been chilled for years and years and years. Are we going to say we're going to do discovery into whether you were chilled from your intended conduct within the last year?
Well, I think at some level that it may require that. In other words, that at a summary judgment kind of stage, did the statute of limitations apply? Was there any sort of harm? Because I think the statute of limitations, could be raised at a later point if there's discovery. But again, that's different. That's different than this case. This case was physical construction. This all evolves or revolves around physical construction, physical paving of a road, and the physical, emplacement and presence of a gate. And that's what the complaint talks about. That's not how we're describing. That's right out of the complaint. And so I think there's a big difference between a law on the books that has the potential to be enforced, even if it's a remote potential. I could see where a court would say, no, the statute of limitations does not apply because there's this potential for enforcement, and it's ongoing into the future. In other words, there's a potential that a government agent will enforce that bad law. In this case, it's a physical construction issue. It's a construction of a gate and paving of a road. And the fact that the council sort of agreed to or put it back on an agenda a couple of times, I don't think changes that. In fact, it goes to that slippery slope that the statute of limitations would never apply to a government decision because it always has the opportunity to revisit an issue. We think that's a huge problem in the case. Other than that, you're all right. We think that this court should uphold the trial court's decision that going to the construction physical presence is what's raised in the complaint, and certainly the council's decision to leave the gate or make the gate permanent, which again is in the complaint, at a minimum, that starts the time clock 4.5 years ago or 4.5 years before the case was filed. And if the idea that the government had a potential to further address it sometime down the road, that was never promised. There's nothing in the complaint.
What if the government, what if the city addressed the location of the gate, decided to move it just a little ways, but the plaintiffs were still aggrieved, at least they allege they were still hurt by that, but now the city had moved it just a little ways. Would that restart the statute of limitations?
It could, and I think that goes to the argument that the plaintiffs made a bit ago that said something about if they decided to open the gate. In other words, if there's an actual change in the decision, if an actual physical, and again, I think it's the physical presence issue. If the gate is then moved 6 feet in one direction to placate one homeowner, let's say, who can now get around it or isn't affected by it, but another homeowner or another party to this particular case has the same impact, I think that it could trigger. But again, that's a new physical construction. It's an actual affirmative change.
That didn't happen here.
Did not happen here, sir.
I see. I think you're making a lot of good practical points, but I'm still pondering why, if the city council chooses to reconsider, rediscuss, and revote, if a citizen who believes that he or she is aggrieved by that and can allege constitutional violations and has standing to do so, in the first place, after 2008, and they reconsidered in 2011 or 2012, well, that's a new governmental action, even though they're ultimately they decided not to take action. But why can't that be subject to judicial challenge and review?
I think it goes to the premise that statute of limitations should be clear and there should be bright lines. And again, I think it creates that slippery slope problem where what if the council heard the arguments? What if they agendized and said, we're not going to vote at all? There's no motion. The item sort of fails for lack of a motion, which happens. Is that an action by inaction of the government that would trigger it? What if? But that's the slippery slope problem. In other words, the sort of policy argument here is it certainly discourages public input and public conversation of issues that may be ongoing. But because we're not talking about a law that continues to be enforced by continued government action. We're talking about a physical construction that sets the time or triggers the time to start running. And so certainly, if at most the idea that when the council said, hey, we're going to vote to permanently leave this in place without any promise, without any even indication that we might consider this in the future, it would really, if the
But nothing's permanent in the world of legislative bodies. One legislature can't bind a successor legislature, right? So there's always the prospect of revisiting a council decision.
There is.
So when they say there's no chance, this is permanent, how significant is that?
Well, I think as to the plaintiffs in this case, it's pretty significant because they were around. In fact, Plaintiff Anderson, according to the complaint and the file and the record, was at that particular hearing. So he knew that the council was at least intending to make it permanent, which should have triggered either some sort of action in court, not within a year period, not 4.5 years later, because again, the flip side of it is if a council is going to rely on this 1-year statute, or a government body is going to rely on a 1-year statute of limitations, then it really discourages any kind of public input or any kind of public discourse or public discussion about an issue that might continue to be controversial, because there's fear that we're going to trigger the statute of limitations again. Don't talk about this. So I think that's a policy argument that plaintiffs, the plaintiff's argument really creates a problem that, in a sense, discourages public discourse. Thank you, Your Honor.
Thank you very much. We have time for a brief rebuttal.
Thanks, Judge. The vote is key. They made a decision to put it back on the agenda in May of 2012 and vote. That has consequences. Just as Judge Swan said, if somebody new had moved here from out of state and had seen that gate there and had found it offensive and thought that it violated constitutional grounds or anything, affected their ability to get to the hospital in a timely manner, and they had asked the council to reconsider the placement of the gate, and the council does so, and they vote to leave the gate in place, that person certainly would have an opportunity to file a lawsuit. The reverse is the same. Our client should have an opportunity when the council decides to put it on the agenda to reconsider. The gate itself is the enforcement. It blocks the access. Thank you, Your Honor.
Thank you both very much. We will take the matter under advisement and issue our decision in due course, and we'll take a brief recess now so that counsel in the next argument can come forward. Thank you.